Since the Shelby County decision, the Voting Rights Act is in a perilous situation. And I commended to my colleagues, and I commend to you, a book entitled White Rage by Carol Anderson, who teaches at Emory. And she talks about the evolution of the issue of race since the Civil War. It strikes me now that we are in dangerous territory about the future of the Voting Rights Act. If pre-clearance is not required, and the Department of Justice is reacting after the fact, there could be some delay in justice here, an intervening election, or no action taken. I asked my staff to give me a listing of the cases initiated by the Department of Justice relative to the Voting Rights Act for the last several years, and it goes on for pages. Can you address this issue about your belief of the commitment of Senator Sessions to enforce the Voting Rights Act in principle post-Shelby County?
Certainly. So, as you well know, Senator, the Voting Rights Act is regarded as the crown jewel of civil rights statutes. And Section 5 was regarded as the most effective provision of the most effective civil rights statute. And so, in the wake of the Shelby versus Holder Supreme Court decision, which debilitated Section 5 being via Section 4B, we have seen nothing less than a Machiavellian frenzy of voter disenfranchisement from one end of the country to the other. And so that means that the Department of Justice has taken on more responsibility, and civil rights organizations have taken on more responsibility with fewer tools. It has meant the debilitation, literally, of our democracy, where we have citizens who have to wait for the violation to occur, as we saw in North Carolina, where the Fourth Circuit, the U.S. Court of Appeals for the Fourth Circuit, held that the state legislature engaged in intentional racial discrimination with respect to voter suppression carried out with surgical precision. It took an army of lawyers, an army of experts, in order to vindicate the rights of the people, and a mass movement by the North Carolina State Conference of the NAACP with so many others and so many other legal groups. The point being here is the Department of Justice not only is a democracy in a perilous place, but the Department of Justice is in a perilous place. It needs strong leadership, it needs resources, and we need a Voting Rights Advancement Act to fix the Voting Rights Act.
And post-Shelby County, if the Attorney General is not timely and aggressive in enforcing the Voting Rights Act, the damage will be done.
The damage is absolutely done. And when we think about all of the many members of this body that went to Selma, that commemorated the foot soldiers of the movement on the Edmund Pettus Bridge, all that they died for, all that they sacrificed for is hanging in the balance. So we need strong leadership there, because literally, we can squander the fruit of their efforts and the civic sacrament of our democracy, namely the right to vote.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator.